Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to be having a chat about an entity that owns a shopping centre sitting over in Western Australia, and the ownership of the company that owns that shopping centre is divided in half. We've got a 50% co-owner over here, that's a company that owns it, and we've got a 50% co-owner over here, that's a company that co-owns it. This company has one director, this company has one director, and these two directors are directors of the shopping centre owning company, right? One big company owns a shopping centre, that company is owned by two other companies. Now, what happens from there is quite interesting, because what we do is we work through the mechanics of what happens here where the two directors of the company no longer get along. Now, the way the shopping centre is set up is that company two over here actually provides services to the shopping centre owning company, and those services relate to the operation of the shopping centre. So they're doing things like chatting with tenants, they're doing things like collecting rent, they're doing things like managing the property, right? They're in there doing stuff. And company one, over time, or the director of company one, has a bit of a falling out with the director of company two. Now, how this arises actually isn't in relation to the shopping centre company, it's in relation to some other projects that these directors have going on together amongst themselves. But on they march. Now, the challenge that happens here is that the director of company one, and indeed company one itself, attempts to cause the shopping centre company to sue company two on the basis that the work done by company two is essentially, according to the relevant piece of legislation, real estate agent work. And if you do real estate agent work when you're not a company, I withdraw that, when you're not a real estate agent, then any payment you've got for that work should be repaid to the person you purported to be an agent for when you were not in fact a real estate agent. Does that make sense? So essentially company one says, oi, company two, you did real estate agent work when you weren't an estate agent, so any money you got for that work should be paid back to the shopping centre company at the heart of it. Now, what company two said is, hey look, that work we did, or the payments we received, were in the nature of reimbursements. So rather than being any extra payments or big profits or bigger sources of return, they're essentially reimbursements for costs that company two incurred, and any investment was designed to see a return for the shopping centre company, not a return here for company two. So there were these various arguments. The reason it came before the court today was that company one sought to bring what we call a derivative action on behalf of the shopping centre company in relation to this. So the complexities that arose were these. As many of you are aware, the way we bring a derivative action is that we've got to tick these 5 boxes. And if an applicant ticks these 5 boxes, then in essence, they're able to stand in the shoes of the company and to sue someone else on behalf of the company. So what company one, or company one's director, is trying to do is to stand in the shoes of the shopping centre company and to sue company two on this real estate agent basis, right? So we've got to meet these 5 criteria, and the parties between themselves agree that the notice requirement is met. They agree that there is evidence before the court, this is another criterion, that the company itself is not going to commence the proceedings, and they agree that there is a serious question to be tried. So section 237 subsection 2A is satisfied, B is not yet satisfied, C is not satisfied, but D and E are. So A, D and E, they're all ticked off, the parties agree. So there's a real argument between the parties as to whether company one is coming in good faith and to whether it's in the best interests that company one be granted leave to stand in the shoes of the shopping centre company to bring this application. Now, these are the issues the court is forced to grapple with. So let's turn to the best interests of the company question. And in relation to this question, the court sort of works through the mechanics of what company one is proposing. What's being proposed is that we're going to go and chase about 700 grand from company two on the basis it was improperly taken by company two because they're not a real estate agent. Now, as part of the best interest test, company one, via its director, offers this indemnity and says, look, we reckon there's going to be about 500 grand in legal costs incurred in relation to running this litigation. And so there's an interesting sort of background commercial calculus that says, well, there's 500 grand that this is going to cost. There's a 700 grand return, and that return is shaky. So in the background, there's this sort of commercial challenge the court is grappling with. So in relation to the best interest of the company, the court says that it's concerned about prospects, it's concerned about these things, but sort of takes the reasons for judgment at this stage over to the good faith requirement, because the court finds that the good faith test is not met in this matter, which means that the plaintiff company fails. Now, the reason the good faith test is not met, meaning that the best interest test does not matter, is for a number of reasons. One of them is that the plaintiff is unable to show that they've got a reasonable basis for their belief that there's a good claim. They can't point to any legal advice. They can't point to any really foundational reason that says, oh yeah, we're going to cause the shopping centre company to succeed in its claim against company 2. There's not enough there for the court to grapple onto. There's also this commercial calculus where we're talking about spending or putting at risk 500 grand that potentially could be recouped from the company, from the shopping centre company, at risk to chase 700 grand, where it's not clear that even if that claim was successful, that you get all the 700 grand back. It's also not good faith because there's no real grappling with this really genuine argument that company 2 is able to raise that says, hey look, we're just being reimbursed here, we're not making any great profits or anything like that. So there are all these reasons standing in the way of the court finding that the plaintiff was coming in good faith. And what that means is that even though the plaintiff was able to satisfy criteria A, D, and E, and even though there was sort of this open question about best interests, because the good faith criterion was not met, because they were unable to really grapple with this challenge they were having in relation to showing that it was good faith that they wanted to come and sue company 2, the application failed, leave was not granted, and as we lawyers say, costs followed the event. I hope that discussion assisted you, and I look forward to joining you again soon for another coffee and another case note. Cheers.